Welcome to County Portal, your simple source for local government services and public records. Let's get started.
How long are recorded jail calls kept? This is a question a lot of people have, whether you have a loved one inside or you're just curious about the justice system. The short answer is, there's no single rule for the entire country. The length of time a jail or prison holds onto these recordings varies dramatically. It all depends on where the facility is located and the specific policies they have in place. Think of it this way, what a small county jail in Texas does is probably very different from what a federal prison in California does. The biggest factor is jurisdiction. Every state has its own laws and regulations about data retention. On top of that, each county can have its own specific policies. So, a jail in one county might keep calls for 90 days, while the jail in the next county over might keep them for a full year. Federal facilities, run by the Bureau of Prisons, have their own separate, more standardized rules, which often require keeping recordings for a longer period. Another key factor is the nature of the call itself. Most routine, everyday calls that aren't flagged for any reason might be deleted after a set period. This could be as short as 30 days or as long as a year or two. However, if a call contains information related to an ongoing investigation, a new crime, or a threat to the security of the facility, that recording will be saved. It gets flagged as evidence. In those cases, the call can be kept indefinitely, for as long as it's needed for the investigation or for future court proceedings. For serious cases like homicides or organized crime, these calls become a permanent part of the case file. It's also important to know who is actually storing these calls. It's usually not the jail itself. Most correctional facilities use private, third-party companies to manage their phone systems. Companies like Securus or GTL handle the recording and storage of these calls. The jail or law enforcement agency then has access to this data based on their contract. So, the retention policy is often a mix of state law and the contract with the private vendor. If you're wondering about a general range, a common policy for non-evidentiary calls is anywhere from 6 months to 2 years. But again, this is just a general guideline. Some places might purge them much faster to save on data storage costs, while others might be required by state law to keep them much longer. The bottom line is to always assume every single call is recorded and can be stored for a very long time. There is absolutely no expectation of privacy on a jail phone call. The system is designed to monitor and collect information, and that information can be pulled up months or even years down the road if it becomes relevant to a legal matter. Thank you so much for watching. We hope this information was helpful. If you found this video useful, please give it a thumbs up and consider subscribing to our channel for more content just like this.